Good night, Belizeans at home and abroad. This is the Belizeans Affairs Show number 102 for Monday, 12th of February, 2024. Thank you for bearing patience with us, tuning in, and hopefully we'll have something to present that may be worth your time and effort. At this point, we'll follow the same practice as we normally do, which is to say we have a word of prayer followed by a short scripture reading, and then the chairman of the program proceeds thereafter. As of right now, the chairman for tonight is not immediately with us, but should be available within the next few minutes, as he recently indicated. So I'll just, in the interest of time and making sure that people don't think that we're not going to have a program tonight, I'll just launch the program, and hopefully, when the chairman comes in, I'll just yield, turn over the program back to him so he can proceed with his program for the night. Uh, Again, my name is Leonard Brackett. I'm one of the panelists on the program, and I'll fill in temporarily as chairman for right now. And I'll just go ahead and do the prayer before following up with the scripture reading. I'll just bow my head for a second. Divine loving Father, we thank thee for having given us the privilege of life and the opportunity to still be alive today among our family members, friends, and loved ones, and to be able to come and present this 102 program. We thank thee for thy mercies, thy guidance, thy protection, wisdom, knowledge, and understanding. And we hope that thou would bless our country of Belize, its people, and its leadership, as well as we pray that thou must bless this country of the United States, its people, and its leadership, and especially the rest of humanity, loving Father, and those who have need of food, clothes, shelter, and who are in harm's way and being hurt, sometimes for no justifiable reason. We pray that thou mayest have mercy upon them, and that thou would give them some sense of solace and comfort. For we ask these mercies in Jesus' name. Amen. Thank you very much, and I'll just proceed to do a short scripture reading from Proverbs chapter 29, verses 1 and 2. Reads as follows: He that being often reproved hardeneth his neck shall suddenly be destroyed, and that without mercy. When the righteous are in authority, the people rejoiceth, but when the wicked beareth rule, the people mourn. And that is the end of the reading for tonight. Again, thank you very much for being with us. Uh, I'd just like to take a second here. Okay, I won't do that. Let me back up a little bit. Uh, Temporarily, until the chairman gets or becomes available, I would like to just. Oops, let me see. It's not coming up. Mm-mm. We can't get it there. I gotta go further down and get it somewhere else. Let me try this one. It's not that either. Just bear with me for a second, please. I thought I had what I would have liked to read, but for whatever reason, okay, I see what happened. Okay. So yeah, got it. Thank you very much for bearing patience with me just now. I had what I needed to read or wanted to read, but I couldn't pull it up from the location where I went. So I had to take another few seconds to go at another location to be able to pull it up. It's just a short reading, and I hope that by then we have a 5:49 San Francisco time, which is 7:49 Belize time, and I'd like to proceed by reading this particular essay. The following comments were made by Leonard Brackett to Mr. Martin Galvez. As part of a Facebook post thread by Ariel Lightfoot in Belize Election Watch regarding Belizean Maya land tenure issue, I titled this particular commentary Belize Maya land tenure issue, and I went on to say, Martin Galvez, they were not allowed to prevail over the Guatemalan army. They, the Mayans, being killed by the hundreds of thousands, but they are expecting to prevail over Belize, where they were allowed refuge and protection and sustenance. They, the Toledo Mayans, are acting as a Trojan horse in Belize to try balkanize Belize on behalf of foreign interests, Guatemala and others, whom may not treat them, the Mayans, any better than they had treated them before, as a Guatemalan backup plan to their ICJ endeavor. How sad. And the context of that is because of the fact that we have always had Mayans living in Belize, Mayans living in Guatemala, Mayans living in Honduras, Mayans living in El Salvador, and Mayans living in Mexico, up in the Yucatan area, and down on the Pacific side as well. As a matter of fact, Mayans have lived and constructed temples in Belize, the territory of Belize proper, many hundreds of years in the past. So it's not like we are strangers to the Mayan community or they are strangers to us. The fact is that as widespread as the Mayan culture and people were in the past, many of them, before the Spaniards came and conquered Guatemala proper, many of the Mayan communities had ceased to exist. And the Castellanos from Spain came to Guatemala and conquered the then indigenous Mayans, of whom I am aware of, as of today date that we're talking, constituted more than 20 different sects or groups of different Mayans, none of whom speak the same language or dialect. And those Mayans in Guatemala were also uh, some of the same people that in the recent past, the Guatemalan Castellanos, them and the military in Guatemala had attempted to, well, I shouldn't even say attempted to because they did, in a massive way, killed hundreds of thousands of those people in order to dispossess them of the lands that they had. It is probable that the Castellanos wanted to take possession of certain areas of the old Maya kingdom, and because these people would not give up their territory, they end up with a civil war in Guatemala. The Mayans in Belize took in and gave refuge to some of the Guatemalan Maya. And at this point now, we have an issue with the indigenous people in Toledo district, namely the Quiche Mayans who came from across the highlands of Guatemala to take refuge in Belize, within the boundaries of what we now know as Belize, to live along the Mayans, the Mopan Mayans, whom we have always coexisted with no problem, and some of the Chol Mayans, whom we have had in Toledo that came across originally from Petén Flores in the area of the Coban, where the Sarstoon River meets the Belize boundary. The bottom line is that these new settlers, the Quiches, have conspired with the local Mayans to attempt to balkanize the country of Belize. Unfortunately, for political reasons, some of the politicians have entered into association and cooperation with these individuals to facilitate them being able to acquire additional lands beyond what they had actually occupied. Why? Partially, the communities kept expanding, and with the new Mayans that came across the border, they kept on expanding and developing more villages. I remember back in the early 50s, well, I would say middle 50s, when I first went to Toledo, there was no such thing as Mayans immediately adjacent to PG. That was mostly the Garifuna people, the East Indians, and some Creoles. The Mayans were way back into the hinterlands of Belize. They kept to themselves until many years after they start associating with the rest of the people in the district. And there has never been any kind of problems. Everybody coexisted with each other. Everybody was entitled to get their own land papers and their lands, like everybody else in the country. And all of a sudden, the issue of Maya land tenure rights for balkanization purposes became the issue of the day. They had people from abroad whom they, the Mayans, are not fully aware of, had other agendas, but were using their cause as a cause celeb. In other words, what would appear to be on the surface a worthy cause. That these foreign agents and entities with their own separate agenda, figured out that they can use as a Trojan horse. Guatemala had always, long before they enter into agreement with us to have a settled border, long before then, they have always coveted the lands of Belize, which back then was British Honduras, and previous to British Honduras as a colony, before it became a colony, it was just a settlement. But that settlement had grown to the point where the people of the Bay of Honduras were not only just living in Belize proper, they were living in Livingston, they were living in Puerto Barrios, they were living in Trujillo, they were living in Bluefields, they were living in Vanaca, they were living in all those islands in that area there. As a matter of fact, some of them were living in Jamaica, going back and forth from Belize to Jamaica. The point is that while the Mayan, as a community, within their own cultural existence or I would say lifestyle, are deserving of having somewhere to live, somewhere to plant, so that they can be able to subsist or feed themselves. Because in their culture, they're not used to going to work for no banana food company or for no other entity in Belize or in Guatemala or anywhere else. They plant their stuff, they catch their fish, they do whatever they have to do, and they survive. They have done that for hundreds of years. Many, many hundreds of years, as a matter of fact. But the issue is that they are being used, some willingly and knowingly, others inadvertently and unaware, for a grand agenda. That is the grand agenda of dispossessing Belize and its inhabitants of the territory of Belize. When the Mayans used to live in Belize and control Belize, the Spanish had no right to go and conquer Guatemala and or hope to conquer Belize, which they never did conquer. They never did occupy and control Belize, except for one instance when they actually dispersed some of the people from Belize City and St. George's Key proper. And a lot of the people ran into the woods, up into the Cayo areas there. Some of them went down to PG area there. Others went to Livingston and Puerto Barrios and Trujillo, as I previously mentioned. And others went to Ratan and Vanaca and other small islands in the bay, as well as others went to Bluefield and the Black River tongues in Nicaragua. The fact that they are expanding and need more territory doesn't mean that they should conflate their needs and make it into just also their wants. Because knowing what they want is not just only what they needed. They needed more land for them to farm or use for a bigger community. But they want now lands far beyond that limit. They actually want all possible Crown lands to be turned over to them for their future generations. That is not how it's supposed to operate. if that were to be the case, then how would the rest of the people in the country manage to, survive and subsist? If one group wants to lay a permanent claim on the lands and the resources below it, that means that basically what they're attempting to do, or what they're stipulating that they want to have done, is to have their own country within the country of Belize. Or for that matter of fact, have their own country even maybe outside of the country of Belize. That is to say, truncate part of what the existing Belize is and turn it into their own country. Because that is the attitude that is being displayed currently, but that was not the attitude that was being displayed when they started out their agenda. But at every step of the way that compromises was being made, they kept on moving the milepost and wanting more and more and more. 20 odd years ago, to be exact, I think it was October of 2000, when Mr. Musa had a discussion with some of the leaders up there, I should say down in PG, well, Toledo, because PG is actually the tongue, no? And Toledo is the whole district. So Mr. Musa, then as Prime Minister, decided to have a meeting with the Mayan community and to try and flesh out what their needs were and how he could facilitate them. From way back then, he had been aware of the fact that these people's intention was to balkanize Belize. And he pointed out to them, the government cannot countenance any balkanization of Belize. So they went around, played a different game, came up with a different perspective, and the one that they are now advocating is to actually ask the government to take away private lands from people, which is unconstitutional to start with. Secondly, for the government of Belize to come up with money to buy lands from private people in order to turn it over to them. Are they not part of the government? Are the Mayans saying that they're not part of the government, but they want the government of Belize to facilitate them by spending the treasury of Belize? I'll go into that subject on another occasion, a little bit more in depth, and provide some more backup and information to substantiate what is it I was attempting to convey just now. But the chairman for tonight is present, and like I said, when he showed up, I would have just deferred to him, and therefore I need to follow through and do that. Mr. Chairman, Mr. Gregory Brackett, I would like to yield back to you the floor, sir, for tonight's program.
Thank you, Mr. Brackett. Good night
You're
to the
welcome.
Belizean people at home and abroad, and welcome to this 102nd show for tonight. My name is Mr. Gregory Brackett, the chairman for tonight, sitting with me virtually, my cousin Mr. Leonard Brackett. And tonight I want to bring some very important matters to Belizean affairs concerning our constitution and concerning laws that is being passed in the House that are unconstitutional and pointed against the Belizean people. But firstly, let me say this. The present government had tried to pass a law just recently, and that law was to raise the common assault from a misdemeanor to a felony with sentencing up to 3 years and 5,000 fines. And as a part of that, they had listed the ministers at the last end of that bill. And we here in Belizean Affair was pointing it out
Mm-hmm.
wanted people to know how unconstitutional that was, that the government would try to silence the people from really talking to their politician, ministers who was elected when they did wrongdoing. And to get to that matter, I have two pieces of tape that I will play to let you hear what have happened just last week with this piece of legislation. Let's go to the first video clip.
Colleagues this morning. Madam President, the NTUCB has a few concerns regarding this bill before us. And while, as everyone has said, I support the comments made by my colleagues, we feel that we are moving away somewhat from using or requiring proof for some of these things when we are looking at, for example, you can be held accountable if I hear that you say something or you say a bad word, as we call it, just by those persons, indicating that they heard me say these things. That can be problematic for me as an individual. That is the view of the NTUCB in terms of reviewing this bill before us, and we feel that while we understand the purpose of the bill, and while it is that we want to ensure that we are not encouraging our citizens, threatening others and doing all of these sorts of things, we have to be very careful that putting this portion in here is not going to affect people's right in terms of your right to freedom of speech. And that's a huge concern for us that we share as it relates to this bill. Again, Madam President, we do understand that we want to have a society that is disciplined, that has certain behavior, but there's a thin line here when we include these words such as whether directly or within hearing. That may create mischief. Because, for example, we were discussing that, let's say, for example, a police officer were to, hold you for something, in the process of arresting you for something, and maybe somebody else is shouting at you or telling you something while you are being transported, and, you may utter profanity. Might not be to the officer or about the officer, but it might be just that you're speaking to the other person who might be around. The NTUCB feels that can create some unnecessary issues, and so I think, again, the essence of what is here is supported. However, I think that this portion of this bill will create some issues in terms of people's freedom and people's rights, and so I don't know how we can look at that. In relation to the categories listed, yes, we do support those. I'm not sure about the elected official, because that's another matter again. How we view that and what it is that we are trying to, is it that we can no longer say certain things to elected officials, when we feel that they are not doing what they ought to be doing, because you have to be very careful what you say and how you say things, because you can be in trouble as well, right? And it's not just, we're going to be charged something, right? It's conviction to imprisonment for 3 years. So as union leaders, we all know that we are often in this back and forth, especially with government officials. And sometimes things do get heated. And if it is that, with Tada Miss Smith, they put me to shame, and Miss Smith putting things out there about us as a union leader, we'll deal with her now to utter these words. And I heard you say these things, so let's go. 3 years imprisonment, you can't do any more union function. So those are the concerns that we have, and we are to ensure that, in putting things in place, we don't infringe on our rights as Belizeans, as given to us by our Constitution. Thank you, Madam President.
Now, my co-host, Mr. Brackett, we
Yes,
have
sir.
beaten this heart. We have talked about the unconstitutionality of this bill, and it's finally coming around so people can see how the government is trying to silence the public. Again, when this bill came out, I said I believe this bill was passed to protect one of their own that was in trouble. And I still have that belief because then when they listed there as ministers at the bottom of this piece of bill, we know what they were trying to do. Now let
Mm-hmm.
me hear you on that. 5 minutes before I play the rebuttal from the House Senator, Mr. Courtney, and hear what he had to say about it. Let me have 5 minutes on that.
Okay. I'll give you 5 minutes right now, Mr. Chairman. Just give me a second. I can pull up exactly what I need to say, no? Or part of what I need to say. The Constitution of Belize is supreme law of Belize. I'll read it as the Constitution states it. Constitution of Belize, Cap 4, Part 1, Section 2. And it has Section 2, Subsection 1, and Subsection 2. I will not entertain a conversation right now, or at least the reading of Subsection 2, because for all intents and purposes, the Supreme Court and the highest court, the appellate court and the Caribbean Court of Justice have already concurred that for all intents and purposes, that particular section, which is Section 2, Subsection 2, is null and void. Yet, it continues to appear in the Constitution without it having been amended and or excised or corrected. So a lot of people won't read it and think that, oh yeah, it's valid, but it was put in there deliberately as a means of trying to grasp powers that were beyond the hands or the reach of the legislature. It was basically a power grab, basically trying to put the legislator above and beyond the reach of the Constitution by making the legislature the supreme entity, as to give the legislator a supremacy above the laws of the country, just because they are authorized to make laws. They overreached and went on to put stipulations in our Constitution that have been ruled as being unconstitutional and null and void. Let me go ahead and read it, please, belaboring. Section 2, Subsection 1 is the part of interest to me. This Constitution is the supreme law of Belize, not the legislator. There's no such thing as the supremacy of the legislator over the Constitution and or over the legal system of our country. This Constitution is the supreme law of Belize, and if any other law is inconsistent with this Constitution, that other law shall to the extent of the inconsistency, be void. That is what the Constitution says. Very specific, without any ambiguity, except for the part that I mentioned earlier, that our knuckleheaded scofflaw legislators in the past had tried to grab power onto themselves so that they can keep making these bogus laws that my cousin and chairman for tonight had been referring to, and that Ms. Smith in the Senate had pointed out are violative of our Constitution. It's another form of bastardization of our Constitution. Why? Because they have the temerity to try and claim that they, under the rights for legislative and lawmaking, could do just about what they want, especially now with a supermajority, and to bastardize our law further. Going specifically to the point that Miss Elena Smith made reference to, the Constitution specifically speaks to the fact that government shall make no laws infringing on the rights of people's speech, communication, and many others. Those are inalienable rights that the government have no prerogative and no authority vested in it to transgress. I would like to read some of that further on, but I would like to defer to Mr. Chairman to play your next tape, sir, because I know the other part of what I was about or would have liked to say right now will be needed in order to correct our learned friend, Mr. Courtney, because he should know better. But he also understands his assignment, which is to come out here in public and bamboozle the general public who is not a lawyer like him and who have to take his word as a professional legal mind, experienced legal mind at that, one of our senior law counsel, for him to come out and be bamboozling the general public, and for the lack of another way of expressing it or saying it, lying to the public, conflating to the public. But we'll deal with him after the fact.
Thank you.
I yield back, Mr. Chairman.
I thank you, Kurt, but I think they are coming to reality. Because here you will find that what we have been saying.
Exactly. We have been saying it over and over and over.
And then
it's not because they don't know.
Let the people at home and abroad hear it for themselves.
Madam President, I would seek first of all to respond to the concerns, because whilst I appreciate that they are legitimate concerns, I think that there is a fundamental misunderstanding of the piece of legislation. It is important, first of all, to look at what the law says now, prior to the amendment. It says, this is Section 4 of the Summary Jurisdiction Offences Act, a person who uses to or at any other person or in the hearing of any person any threatening, abuses, profane, obscene, indecent, or insulting words or behavior, whether calculated to lead to a breach of the peace or not, such several offenses being committed in a street or public place or in a private enclosure or ground, is guilty of an offense. The law today says if you use to any person in the hearing of any person Any threatening, abusive, profane, obscene, indecent, insulting words or behavior, whether calculated to lead to a breach of the peace or not, such several offenses being committed in a street or public place or in a private enclosure or ground, is guilty of an offense. What Senator Perry-Feet described, his example of having a barbecue, drinking with his friends, behaving the way he usually behaves, he would be guilty of an offense today. Now let us look at what the bill proposes to do, Madam President. It says, first of all, we are going to repeal the provision that I just read. Now look at what the proposal says. A person who uses any threatening, abusive, profane, obscene, indecent, or insulting words or behavior, which is what is in the law at the moment, whether calculated to lead to a breach of the peace or not, which is in the law at the present, such several offenses being committed in a street or public place or in a private enclosure or ground, which is what is in the law at the moment, whether directly or within the hearing of. Now recall what I read. The law as it stands today does not have any category, does not have any class. It says anybody who do them things and anybody hear it, anywhere, it's an offense. There is now these limiting words. If you do it within the hearing of a person acting as a judicial officer and legal officer or a peace officer. So it has to be not a police officer walking down the road. He has to be performing his functions, and this happens. Then an offense is committed. And look at the rest of them. A member of the Belize Defense Force in the course of his duty. Coast Guard in the course of his duty. Immigration officer in the course of his duty. And it continues. Custom officer, National Fire Service, public officer, prison officer, teacher, member of the media, and then we can discuss elected officials. So this is limiting the provision that is on the books today and saying when these public officers, whether they be police, BDF, Coast Guard, a judge, etc., are performing their functions, it is an offense to hurl offensive, abusive, insulting words or to conduct yourself in such a way. It is seeking to address a problem, a mischief that we have, where immigration officers or police officers conduct searches and they are being abused by people in the course of their duty, not walking down when you're having a barbecue. And so, Madam President, I want to say to honorable senators that this is reducing the scope of what is actually on the books of the law books of the country today. It is only applicable where the person is in the course of his or her duty. It is absolutely essential. The complaints from these officers are many. The abuse they receive when they are performing their functions. In relation to 11, an elected official, I am entirely open to having a discussion in the committee of the whole Senate when this bill is being considered as to whether members think it should include senators or to be removed at all. Other than that, Madam President, I commend the bill to the Senate and ask that the question be put.
Now, people at home and abroad, as we said before,
Mr.
he
Chairman?
know they have to remove it because it is what? Unconstitutional. Go ahead, Mr. Brackett.
The learned Mr. Courtney, I need to flag him again, okay? He knows exactly what he is trying to do and why he persists in wanting to make amendments to the existing law. Not to say the least that the existing law was amended before. If anyone who's been paying attention to these guys going to our house and making amendments to our laws, they had made amendments before that was also unconstitutional and violative of good governance and good order, which is what the responsibility of the government first and foremost is supposed to be about. To use the laws and our constitution to manage our country, give the people good governance, and to make sure that any laws that they make is made not for their own self-protection from the wrongs that they do and what people complain about, but for them to not violate the Constitution in the first place. Otherwise, they're scoff laws. And according to him, right now, my telling him that he is acting as a damn scoff law would mean that he, as a officer of the government, an employee of the government, in the process of doing his job, like for example, right, those standing up right there in the Senate and articulating what he just articulated, to him, he could take offense to what I'm telling him. And under the present circumstance of that particular law that they're trying to enhance, because like I said before, they had already made, came and modified what existed before, and now they're trying to modify it again. Why? They want to include themselves as political officers in that particular group of people who they are claiming should not be offended. That you can't say nothing to, or you can't talk too hard to. Otherwise, they could say, well, you offended them, or you said something that caused them some kind of pain and suffering, or grief, or psychological stress, or whatever. Especially if you do it while they're going to the Senate, or leaving the Senate, going to the House, leaving the House, or going to their job as ministers, or leaving their job as ministers. And even as a matter of fact, like he stipulated earlier, if any of them hear what was said, whether it caused harm or not, he is saying that you're liable to go to jail for 3 years. Now, I want to call him a damn knucklehead and an idiot. As intellectually competent and smart as he is, I'm calling him like that because he knows better, but he's trying to bamboozle the public. The Constitution, remember what I read, the first thing I read just now. The Constitution is the supreme law of the land, not these bogus laws that they go about trying to make to try and protect themselves from people complaining to them about the wrongs that they're doing. And that is what they're after. The last time they remodeled the law, they left out themselves. And they've been getting a whole lot of flack for the craziness that they have been doing. So they want to silence people, like myself, for example, and all others, including the media houses them that ask them tough questions that they don't want to answer to. Let me read what I was about to read. Okay, let me turn this thing sideways so I could. Okay, Mr. Courtney, I hope somebody give you an opportunity to hear what I'm about to read here, because you don't have to go check it in your own copy of your Constitution. By now, you're supposed to know this by heart. Protection of freedom of expression. The Constitution of Belize, Cap 4, Part 3, Section 12, and Subsection 1. There are other subsections, but I just want to read Subsection 1 for right now. Reads as follows. Let me enlarge it a little bit. Okay. Except with his own consent. I'm not talking about Mr. Courtney's consent. I'm talking about me or anybody else. Well, let's include him because he's also a Belizean, right? And he also comes under the Constitution, but he's acting like he doesn't. So therefore, he needs to have the House create one new law in order to protect him. He don't want the protection where the Constitution grants him. He wants to create a new law to grant himself exception, and his other colleagues who are getting a beating for the political things that they've been doing and all the other things that they've been doing. At this point, if the election were to be held, they'll probably lose to a party that has no true foundation right now. And why they would lose? Because they've been beaten up substantively over the last year and a half, 2 years. And they take resentment to that. They don't feel like they should have to suffer no consequences for their wrongdoing. They prefer to victimize the people who are complaining about them victimizing the people. Let me read this stuff now, please. Except with his own consent, that is a Belizean, a person shall not be hindered in the enjoyment of his freedom of expression, including freedom to hold opinions without interference by the government, freedom to receive ideas and information without interference from the government, freedom to communicate ideas and information without interference from the government, whether that communication is or whether that communication be to the public generally, like we are doing on this platform and others do in the media, okay? Or to any person or class of persons, and freedom from interference with his correspondence. You know what your correspondence is? Your letters, your text, your videos, your pictures, your reporting as a media personnel, okay? And we constantly flag them, but that they want we get off of we high horse and stop embarrassing them for their shortcomings. That's what that law that he's quoting there is all about. They modified that thing a few times before. What he is reading, what the first part when he first read it out after his telephone, right? When he first got up and read off of his telephone, he was reading from a previous, well, he was reading what the law says right now on the book, not the one that they're trying to pass now to change the one that is on the book. Okay?
On Thursday, members of the Senate debated a controversial amendment to the Families and Children Act.
The biological father, the biological parents of a child should under no circumstances be relieved of the responsibility of maintaining their children and putting it on the shoulders of someone else.
The legislative amendment was encouraged by a High Court ruling back in September 2023. The court ruled that Section 48, subsection 1 of the Families and Children Act was discriminatory.
That section is discriminatory because it imposes a liability on a man to maintain not only his children, but also to maintain the children of his wife who are living with him at the time. Whether those children are his biologically or not.
With the High Court ruling in favor of the unconstitutionality of that subsection, an amendment was necessary to reflect the judgment. But a section that may not be common knowledge also exists under Section 48 of the Act. Section B states that every man is required to maintain his own child and the children of any child of his.
The point of the matter is that the law is there, the Families and Children's Act, and the amendment that was made in order to ensure that children are maintained. That is the first and foremost responsibility that the Act is putting on people, adults, when you are in a family situation. You could adopt a child, you could be fostering a child, and that child becomes what you call a child of the family.
Dolores Balderramas Garcia, the Minister of Human Development, explained that the obligations to a child falls on either the paternal or maternal grandfather under special circumstances.
But here's the thing that was mentioned. Why would you place responsibility, for example, on a grandparent? No, we're not saying that elderly people should be mining picnic. That is not what we're saying. But if you read the thing carefully, and that's why I say some of them just like to argue. If you read the thing carefully, it is saying that you look at the responsibility only where the biological parent, mother or father, they cannot be located, they are ill, or they are unable to maintain themselves.
Notwithstanding the fact that this has been enshrined in the laws of Belize for many years, Michael Perifit, the lead UDP senator, argued on Thursday that Parliament has an opportunity to make certain changes.
The court is the court. And if the court has made a decision, if they interpret the law in such a way as it is written, and it comes with a result that's not what we accept or what we like, with all due respect to the court, we are Parliament. And they can make a decision in the High Court, but we in Parliament, we make the law. This is an opportunity, Madam President, to make a law that is sustainable to people and makes sense.
Would Cabinet consider reevaluating this approach if there is a great deal of public concern that warrants such?
I wouldn't say so. I wouldn't say so. We have rich discussions in Cabinet about the social issues of our country, and we have many people everybody, I would say, who are very concerned about our social issues. But I wouldn't say that we should prolong the conversation. I think again, I have said and I repeat, the best interests of children have to come first.
And concerns did not only come from Senator Perifit. Other senators raised issues of unfairness.
I know that there seems to be an effort to secure the well-being of children, and I think that is a noble effort. I think that in the instance of the grandparent, where it becomes mandatory that they maintain children, where their children are unable to, whether through loose lifestyle practices or whatever it is, I think it's extremely unfair.
I look, Madam President, at, for example, my own father, who passed away about a year or so ago. He was about 92 when he died. He had one son. So just imagine my brother had children that he didn't take care of. My grandfather, who was 92, 91, based on this law, because this was the law back then, could have been held accountable for any child that my brother didn't take care of. Am I correct, leader? Because that was the law. And so how then could my poor father, the grandfather of these children, not working anymore, being 90, 91, 92, be able to take care of these children?
Reporting for News 5, I am Paul Lopez.
Greg?
No, my good cousin and people at home and abroad, here is another constitutional law that is violating equal protection under the law, which is Section 6 of the Constitution, including Section 5 of the Constitution, life, liberty, or property without due process of the law. I can prove it right here now that we are live, that this law that they are passing is inconsistent with the Constitution and it will be repealed. It cannot fly. And I will tell you why. I want anybody living at home and abroad to read Section 51 of the Family and Children Act. And I will scroll it so that you guys can see what it says. Section 51 says, every person born in wedlock has a moral obligation to maintain his father or mother and grandfathers and grandmothers in case the father or mother or grandfather or grandmother is, by reason of old age or bodily or mentally infirmity, unable to maintain himself or herself. So this law is bumping heads with Section 51 of the Family and Children Act 173. And I will post it so people can see. There it is. Every person born in wedlock has a moral obligation to maintain his father or mother and grandfather and grandmother in the case the father or mother or grandfather or grandmother is, by reason of old age or bodily or mental infirmity, unable to maintain him or herself. Does anybody out there know what moral obligation means? Moral obligation is non-binding. The court cannot enforce that you have to mind your parents. That is something that is obligatory. Likewise, the court cannot enforce a contract between a grandfather and his daughter or his son kid. It's unconstitutional because the law. Go ahead, Mr. Brackett.
Section 6, subsection 1 says, all persons are equal before the law and are entitled, without any discrimination, to the equal protection of the law. The grandfather or the grandmother cannot be emburdened with the responsibility of his son for the caretaking of his grandson or granddaughter. Constitutionally, that is a valid and viable position to be in. What the current government is attempting to do, and past governments have attempted to do under the Family and Children Protection Act, is to exculpate. Remember that one word. I'll say it again. Exculpate. That is to say, or in other words, it means relieve the person who is supposed to have the burden and discharge the responsibility of that burden from that from that burden. In other words, why we have a children's department or a family court and a family department is to make sure that if the parent can't take care of the children the state, the government, the state have policies of state that looks after the interests of a child, a defenseless child, or a child that is unable to look after itself if its parents cannot look after it. That's the responsibility of the state, all of us. But some people in the state, some of us, don't want to take up the burden for nobody else's picnic. Or in other words, we don't want to pay tax to make the government take care of its obligation as a state. So we are glad, or some of them are glad, when the state going to try to come up with these bogus laws to say, well, the grandfather or the grandmother, regardless of whether they are informed or not, so long as they own some asset or have some material substance, should take up the burden of taking care of their grandchildren. Not only morally or willingly, but legally as a burden placed on them by the state. In other words, the state exculpates itself from its moral obligation and legal obligation and put that obligation on the grandparents. Why? Because they can
the woman. But the papers I got from the National Assembly sent to me, it only speaks about man. Section 48. We're talking about 49, okay. So 48, but 48 remains the man. Okay. Madam President, I do not support. The court is the court. And if the court has made a decision, if they interpret the law in such a way as it is written, and it comes with a result that's not what we accept or what we like, with all due respect to the court, we are Parliament. And they can make a decision in the High Court, but we in Parliament, we make the law. This is an opportunity, Madam President, to make a law that is sustainable to people and makes sense. You do not have to follow every ruling of the court if you think that the ruling of the court brings about a result that is untenable in our society. You have to follow it if that's the law and that's the ruling, but we as the National Assembly have an obligation to pass laws to correct what might be the current laws in the country. We have an obligation and opportunity, Madam President, to look carefully at the current law, what the court has decided, and we can change that. That is the power of Parliament. We have equal powers as the court, as another arm of government. They're not superior to us. We make the laws. And I am saying, Madam President, that the laws that we are trying to pass here today, in my view, are very, very egregious. It may seem noble, it may seem like you're trying to find some way, but it is tough because you're not considering consequences. Just like when you want to have a person be in school till they're 16, which is a noble concept, But if you don't have the infrastructure to support it, then you can't accomplish it. Madam President, according to this, I have a child. And Madam President, no matter how hard some parents try, sometimes your children don't turn out the way they should turn out. It's very unfortunate. So now me now, I'm 85 years old, and I can only run 5 miles a day as opposed to the 10 that I run today. I'm receiving a pension and small social security. And my son, who is not able to maintain himself, has 3, 4 children that he doesn't maintain. That falls on me as an elderly grandfather with limited means. You get to the same problem. How can you expect people to take on the responsibilities of another human being? You know, Madam President, the great dealer, you know, once you coined a phrase, like he's the first person I heard it from actually. If you dead, then I'll bury me.
Mr.
Now
Chairman?
there you have it. Another unconstitutional law. You cannot place a contract on grandparents. You know why it is a contract? The Family and Children Act is administrative. It is not judicial. And I will tell you something else. You know why it's unconstitutional? It violates due process and equal protection under the law.
Exactly what I
The
just read.
government, let me give you the distinction between married and non-married couples. The government is not going around to married people to find out if they're taking care of their children, as they are doing when non-married people go to court. The government is not forcing married couples to continue to support their kid once they graduate at 18. When you turn 18, it is over. It's up to those parents if they want to pay for your college. That is why it is not. They are acting under the color of law, and
Exactly.
you cannot have that. Secondly, in administrative things like family court, you cannot sentence a custodial parent to jail if they cannot pay. If they cannot pay that support, because you know what? There are forms in the act that you should give them that they must fill out to show why they cannot pay the child support. And you must do this before you do that. So again, it makes it unconstitutional. But as I was saying, you cannot have 2 different sections of the Family and Children Act. One section demanding that grandparents take care of their grandkids, and then the other section demanding that their kids maintain them when they get old. It's unconstitutional and is inconsistent with the Constitution. Let me hear you, Mr. Brackett.
As I stipulated earlier, the government is trying to shift the burden from the state, which is supposed to produce policies of state to deal with these egregious situations. As you rightly stipulated earlier, even if the parent doesn't have a job or can't come up with the money to pay the maintenance fees to take care of their offsprings or their children, it is then the right and the responsibility of the state to step in and find a way to look after the rights and interests of those children who are under the Constitution entitled to them being looked out for. And it goes further, as you stated earlier too, as well, Greg, that even the government cannot send those individuals to jail when they can't come up with the money. That's prohibitive. If you look under Section 7, as well as Section 8. But let me skip those. And I want to go to, was it Section 10, I think it was. Give me a second, please. Just let me. No, that's freedom of movement. I want to jump. I think it might be
What
12.
they're really doing,
Wait, Greg, give
yes,
me except with his own consent, a person shall not be hindered in the enjoyment of his freedom of conscience, including freedom of thought and of religion, freedom to change his religion or beliefs, and freedom either alone or in communication with others, and both in public and in private, to manifest and propagate his religion or belief in worship, teaching, practice, and observance. There's something else I wanted to read there, but what I'm trying to get at though is that in our Constitution there is a section there that also speaks to the fact that, as a matter of fact, it's the same part of the Constitution under which the government lost its case to the sugar industry. The government is not empowered to force anybody to use their own wealth or material possessions in any particular way. It's unconstitutional. So how the devils they want to get from the point of having to deal with the parents that they can't send to jail because they know they come up with the maintenance money, and go way to grandparents them. If you go try to the grandparents them out of whatever they have for their retirement, just because the government does not want to take on its legitimate responsibility as the state to look after the interests of the minor. That's why we have a Department for Child and Welfare. And Ms. Valderrama should know better than what she's saying to say what she's saying the way she says it, unless she doesn't read our Constitution as well, and she's just going on emotion. She's responsible for that department, and she should know or should get consultation if she don't know. Go ahead, Mr.
I
Chairman.
almost guarantee you,
I'm going to find it.
100%,
I'm going to find it because I need to read it so people could hear.
this bill will not fly. I can almost guarantee you that 100%.
But Mr. Chairman, you hear what Mr. Senator Courtney said. What they're referring to and the changes that they're trying to make is on something that was already in the Constitution. And I tried to point out that yes, it may have been in the Constitution the way he read it,
It's still
but that was based on
unconstitutional.
changes. It was not like that originally, because it could not be like that originally. Nobody in their right mind would have me do that.
Let me say this, right? You see what is calling on the bottom, as I said.
Yeah, I can't see it.
People
It's too
need
small.
to understand what moral obligation is. It's non-binding. You cannot be taken to court to maintain your parents, and they enforce it on you.
It's illegal.
Moral obligation is non-binding. Likewise, the court cannot set a contract between a grandfather or grandmother, a son and a child. A court cannot get involved in
Mr.
what is
Chairman, Mr.
called,
Chairman,
yes,
I agree with what you're saying there, but not the way you're saying it. For this reason, a grandparent can ask the court or the social service people to let them take over custody of their grandchildren as the first priority instead of grandchildren going to a stranger, an outsider. If the grandparent is financially capable of doing it, that's a voluntary issue. It's not a mandated issue by law because morality and legality are not one and the same, which is the point I think you're trying to bring across when you say, while it is a moral issue between family members to look after each other, whether grandparent or grandkid or whether children or parent and children or whatever the
no.
structure is within the family.
What I'm
You're
trying to
correct.
say,
You're correct.
what I'm trying to say, listen to me.
Go ahead, sir.
Moral obligation. Every
Does not equal
child
legal obligation.
have a moral obligation to look after the elderly, but
Right?
it's non-binding by law.
Right?
Likewise,
But they are
a
trying to make it.
court,
They are trying to make a law now to enforce it
it
as a legal and
cannot.
a constitutional,
It's
and it's violative of the Constitution,
unconstitutional.
which is the point that you're bringing forward.
A court cannot get involved in informal family relation. A
Exactly.
grandparent could say, I help you mind your kid, a grandfather, but the court cannot pass a law to enforce that. It's unconstitutional because
Greg,
they are setting a
Greg,
contract.
Greg,
Go
the
ahead.
court is not passing a law. They in Congress are trying to pass a law, but that law is
Right.
violative of the Constitution and the rights of the individual, and they should not find themselves in any position trying to make any such law to violate people's constitutional rights. I don't care if all 100% of them in the House and the Senate get together and pass that law, it is still unconstitutional. Them passing it not make it constitutional. The Constitution have its own boundaries, the four corners of the Constitution of Belize, and they have to come up with a law within that boundary. If they make a law outside of that boundary, it's unconstitutional, it's violative of the Constitution, and it's null and void. But they don't want to hear that. As lawyers,
But
Mr. Perry knows that too. Mr. Courtney
they
knows.
will, I can guarantee you, they will have to change it because Section 49 is bumping head with Section 51. You can enforce that a grandparent mind a grandkid by law, and then in 51, you are asking their kids to maintain them when they get old. How can that fly? It's inconsistent with the Constitution. And not only is it being done on moral obligation, the court is getting into informal family arrangements. You can make arrangements with your kids to help out with these children. They cannot enforce that on you, just as the same they cannot enforce on your kids under Section 51 that says moral obligation to mind you when you get old. Period.
We have had
It's
cases.
unconstitutional.
We have had cases that were ruled exactly like what you just stipulated. We have had cases that came out ruled on that particular point. But they don't want to listen. They don't want to
Anybody,
follow the court. They don't want to follow the court order.
any,
Like we say,
let
okay,
me,
I got to go to Mr. Parafit quickly, before we leave off. Mr. Parafit
Mhm.
was stipulating that Congress makes the law. And if the court interprets a law that Congress makes that comes up with a different outcome than how Congress thought they had written it and it should have been interpreted, then it is the responsibility and the rights, an obligation, as a matter of fact, I would call it, an obligation of Congress to go back, revisit the law, rewrite it, or correct it, or do whatever needs to be done in order for them to work within the Constitution and make that law valid and constitutional. But the fact that they have the authority to make laws doesn't mean that they can make or authorized to make laws that are violative of the Constitution. They have a bar that limits their ability to make those laws, and they just can't go and make any willy-nilly law that violates the Constitution and expect that the court will not strike it down. Now, if they go and make the law within the Constitution, the court should not be able to strike it down because then it remains constitutional. But when the court, under judicial review, Section 20, points out to anybody that comes before the court that something is deficient, then it has to be remedied. Okay? So I was saying about Mr. Perefit, for example. He knows that Congress is authorized to make laws, but the way he was expressing his thoughts is equal to the way Mr. Barrow was expressing his thoughts when Mr. Barrow authorized the inclusion in our Constitution of Section 2, subsection 2, which for all intents and purposes was a bastardization of the Constitution, because it was turning the Constitution on its head to declare that the legislature is the supreme entity of authority in the country, when in fact that's not the case. The Constitution says that the Constitution is the supreme law of the land, not the legislators. And he was trying to grab powers to make themselves a supreme legislator, to the point where he even said in Section 69(9), another bastardization of the Constitution, to try and grab power, when they say, for all intents and purposes, and because all the powers of that was vested in the legislator was final, and the court cannot review any of the laws that the legislator make and find it unconstitutional. That once the legislature ruled on it or passed it, it was beyond the court to amend or to demand an amendment on. Let me go find the stuff and read it. If you come up with something else in the meantime, Mr. Chairman, just give me a couple of seconds to find this thing and read it, because I know a lot of people think that I'm just spitting out stuff out of my mouth and my head that doesn't go the way I'm saying it.
For anyone who wants to know the legal side of what we are saying and the school bar, they can look up Jones versus
69.
Paravaton.
Yeah, but most people wouldn't have that, Mr. Chairman. Most people wouldn't have access to that information, you know.
Some people will.
Unfortunately.
Tell them to look up the case law, and they will see exactly what I am saying, why it is unconstitutional, and the court cannot make a contract between grandparents and grandchildren and a son. They can look it up. Feel free to look it up right there. Likewise, look up the Family and Children Act, and you will see in Section 51, it says moral obligation. Every child has a moral obligation to take care of their grandparents, grandfather or grandmother. Therefore, Section 49, where they are demanding grandparents take care of their grandchildren, is inconsistent with the Constitution and null and void.
Here it is. I'd like to read it, Mr. Chairman, exactly as it appears in the Constitution. It is, okay. this particular, okay, let me, it's section 69 of the Constitution of Belize, as modified on the 11th or November of 2011, just as I said earlier, during the administration of Mr. Barrow, the former Prime Minister. And I would like to read it, like I said, because when I was speaking to the matter off the top of my head, and without reading it exactly, people would think I was just blabbing off and saying things when I got so, like I said. But listen to the exact words and tell me if I wasn't saying the correct thing. Subsection 9, which was added by Mr. Barrow as well, it says, for the removal of doubts, it is hereby declared that the provisions on this section are all inclusive and exhaustive, and there is no other limitations, whether substantive or procedural, on the power of the National Assembly to alter this constitution. Which is to say, in other words, then, they are claiming so much power unto themselves, violating the constitution, and declaring themselves a supreme legislative body with power over all the constitution and beyond the constitution, for that matter of fact. When they included this in 2011, November of 2011, this was a power grab. The court had struck down matters that the government thought they should be allowed to get away with. And they resented the fact that the court had interpreted and ordered the government to make amends and do the right thing as per what the constitution required. But they wanted to just dismiss what the courts were saying and run ahead and do what they want, and the court should have no jurisdiction. In other words, they were overthrowing the legal arm of our government. Remember that question where Dodo, Prime Minister, asked the leader of the opposition, do you know the 3 branches of government? He, as the leader of the administration, the executive administration part of government, is standing up in the House because he has to get elected in there, first of all, before he could have a majority and then constitute the government, playing 2 parts, legislative as well as administrative, and trying to violate the 3rd branch of government, which is the legal part, right? So they constantly violate our constitution. They are the gross violators of our constitution. They commit crimes under the color of law and the authority of lawmaking. They overreach in the authority of lawmaking and try to create laws like in the case here with this one in Mr. Barrow, that was totally out of their reach. He had no powers to be able to do that and make it become effectively so. But he went ahead and did it anyhow. But it still remains unconstitutional. He violated the constitution. He tried to wring a strong power from the judiciary by using his powers of administration as well as his powers of legislation, and to try and tell the court, go take a hike, when the court have equal powers into the 3 sections of government like any of the other 2. And it is the court that interprets the constitution and any laws that they make, and which decides whether or not, if a law that is made by the House, no care if they're all 100% and then get together and make it, whether that law is violative of the constitution or not. The House can't decide that one law is valid. It's the court that have that responsibility within our structure of governance. let me
And you know what's so crazy? And we are both right at that time. We are over that time.
yes,
You
sir.
know
We're
what
gonna
is
take another 5 minutes
crazy?
just so we could close off clean. Go
You
ahead,
know
though.
what
You
is
were saying
crazy
something.
about the law? Let me put it to you this way, and to the people at home and abroad. If they pass this bill into law, stipulating that grandparents must maintain their grandchildren if the father and mother can't do it, you know what that does? Then the court has no authority under administrative privilege to sentence any parent to jail. You heard what I just said?
Mm-hmm.
I hope they know what they are saying because it will open lawsuits against the government.
But
If you try to put me in jail and you are saying my grandparents should help me take care of my kids by law, that's illegal and unconstitutional. It's
but
crazy lawmaking.
these scoff laws, who's supposed to know better, don't care. They create these bogus laws, and unless somebody have the opportunity to take it to court for the court to rule on, those bogus laws stays on the book, and a lot of people are being hurt by it and with it. These scoff law leaders that we have are unconscionable because just like Miss Elena Smith had mentioned in her presentation in the Senate, how can anyone had expected her dad before he died at the age of 92 to have had to be in a position to be responsible for any of the grandchildren them and their needs, especially if he wasn't getting any kind of income. The law says what the law says, and if the law says that he's responsible, whether he has the income or not, he's responsible. So if he can't come up with the money, then under the law, they're sent in a jail, which the law also and the Constitution also prohibit, right, for them to do. But they keep writing this bogus law, which is why they keep losing case after case after case. And even though we have these programs and we point these things out, it takes them months before they react to it and do something about it. And even when they try to do something about it, they're not doing it correctly.
I believe they are making this law to take the burden off the government
Exactly. That's what
because
I said before. That's what it's all about.
you know when a parent can't take care of his children, the state take them over.
That's
But
the
you know
obligation
what
of the
makes
state.
this law so bogus?
But that
I
is the
will tell
obligation
you
of the
why.
state.
I will tell you why. And they are putting this on grandparents who, as you said rightfully, should be the first one to take these kids into custody and take care of them. Look what
But that is
happened
a
with the child.
but that should
Look
not be a
what
mandate from the state under
right.
law.
But
That should be a
look
personal choice made by, like you said, a moral choice made by the grandparents if
right.
they can afford it.
And you know what? Look what happened to that child that was placed in the hands of the Middlenites
Hello?
outside of grandparents or aunties.
Why? Because the government no want to give the auntie them the money or the family members them the money. They prefer to give money to strangers. Okay? It's all about money. It's all about resource. And the way the system is set up is that very seldom do they give any kind of support to the extended family members who would like to keep those kids in the family. Then figure those extended family members should come up with the money and government should keep its own money in their pocket, not meet their obligation as a government. Because the Constitution directs the government that we, the Belizean people, require policies of state that accrue to our health and well-being, safety, and security. They are mandated. So when they come and want to get elected and then do get elected, they're supposed to do the job. So if Mr. Valderramos doesn't know, and I would hope that Mr. Courtney knows, he needs to work and change the rules or the laws so it does what it's supposed to do and not have the rules or the laws victimizing people further. The only reason why they're trying to make this last change right now that they have in the House currently and in the Senate debating is because they went ahead and added themselves at the end of that group of people. Somehow they figured the
That's
last time they
true.
made a change, they had left themselves
That's
out.
true.
Now they're getting
And as I
flagged right,
said,
left, and center, and they can't take the political pressure. So they want to come up with means and ways to silence people. And I
freedom
don't
of
tell them already.
expression,
I don't tell them already. They will keep making
freedom
all
of
the laws
speech
that they
and
want.
freedom of expression.
They could make
They're trying
all the
to
laws that they
silence
want.
people.
The only way they will stop me and flag them but is if the constitution change. Because as I tell them, the modern way of politics is to hang the constitution around their neck. And if they can't carry the weight, get the hell out of the way. Simple as that. Mr. Chairman, we're beyond. I guess we could take another minute or two to clean up and
Right.
close up, no?
With that
If you don't
said,
mind.
as I was saying, the government cannot make a contract between grandparents and grandkids or their children. Likewise, vice versa, it cannot happen. They need anybody, look up the law that is flashing on the banner. Anybody can look up the Family and Children Act, look at the new law that is passed, and go look at section 51, and you will see what makes it
Conflict.
unconstitutional.
Conflicting.
Conflict of interest.
Mm-hmm.
You can't order grandparents to mind grandkids if the father and mother can't do it. When you have in section 51, you want them to mind their mother and father. How will they do that if they can't mind their kids? It's crazy.
But Ms.
And again,
Valderramos, Mr. Chairman, Ms. Valderramos is
uh-huh,
articulating a skewed version of the facts. You know, she's hoping that that's the way it would work out, and they're trying to make it work that way by virtue of making the changes that they are making. But the changes they are making is going to create more problems. And I don't understand how they can't see these things ahead of time. Because it's very obvious they're trying to solve one problem by breaking the law somewhere else. You violate the Constitution one way or another. You try to solve one problem by breaking the Constitution. That's untenable.
well,
But I yield
as
back,
I
sir,
said
and we gotta
before,
close. We gotta
see
close.
if anybody should have known, the present government should have known. You cannot do that to grandparents because you already not paying retirement. You're not paying these people what they deserve. They're not getting their retirement. They leave it as social security. They can't fend for themselves. And likewise, you are the one who have these fathers and mothers can't take care of their kids because you are not getting with private sector to create jobs. You cannot take care of what? External and
Internal.
internal policy.
Mhm.
With that said, I think we have
Nice
come
program,
to
Mr.
the end of
Chairman.
our show.
Nice program. God
I want
bless.
to thank the people that have tuned in. Hopefully, we have enlightened you with some educational purpose and Belizean affair. And looking forward to see you guys on Wednesday and Friday. And I thank you for sitting virtually with me. With that said,
Uh,
I would
there's
like to
one.
say
We have
good night to the people
a
at home
Facebook
and
user
abroad.
that was saying good night all. Thanks for the
Yes,
comment.
we appreciate each and every one that has tuned in and listened to us. With
And I'd
that
like to
said, I would like
apologize,
to
Mr.
say,
Chairman, because the last program we had on Friday, I never, from then till now, I never had the chance to get back and respond to the individuals that had posted their comments on last Friday. So I'm just trying to apologize in public now for my shortcoming, but I'll get around. I'll find somehow the time to get around and respond. I was hoping to do it before tonight, but it didn't work out.
with that said, again, good night to the people at home and abroad.
We want everybody. We want everybody. Give me some of your everybody. Give me some of that cassava. We want everybody. We want everybody. Give me some of your everybody. Give me some of that cassava.